Hello everyone, good evening. Welcome to Hani Law Channel. So today we will have our online discussion on the midterm coverage of administrative law. Actually, I had a Google Meet discussion with this topic earlier with my Bukidnon State University students from Alubihid and Baungon satellite campuses. But unfortunately, due to technical difficulties, the same was not uploaded via YouTube or there was some problems with uploading. Anyway, I will just have this online discussion without them. I hope that they would be able to view this YouTube channel's video later for their discussion with their classmates later. Okay, so we have here with us some students actually have sent me messages earlier regarding the module. Okay, so at Bukidnon State University we're having module, but since we don't have face-to-face interaction with the students, so for this particular online discussion I will be using the midterm module that I made for them or prepared for them. So I'm going to show you now the module. So this is the module. As you can see in the module, there are some chapters here. Okay, so we have 4 chapters. So the midterm module for my Bukidnon State University students consists of 4 chapters. Chapters 1, 2, 3, and 4. So for chapter 1, it's on the introduction to administrative law. Second chapter is control of administrative action. Third chapter is on powers and functions of administrative agencies. And the fourth is on administrative procedure. So let's start. Part 1 or chapter 1 is on introduction. I have already mentioned to my students about this one, administrative law. Administrative law is defined as that branch of public law dealing with the doctrines and principles governing the powers and procedures of administrative agencies, including especially judicial review of administrative action. Because although the administrative offices or agencies are under the executive branch of the government, these administrative agencies are actually having this quasi-judicial as well as quasi-legislative functions. So when you say quasi, in Bisaya pa, murag-murag, pero dili gyud siya mao. So when you say quasi-judicial review, it's actually those functions given to administrative agencies, okay? Administrative agencies na sila'y judicial function to decide on controversies lodged before their offices. So for example, kaning Commission on Audit, Commission on Elections, they have this power actually to decide on cases that are lodged before their offices. So that function is actually judicial. Okay, you are actually deciding cases, so kana siya judicial man siyang function. An administrative agency is any governmental authority other than a court or legislative body performing rulemaking. This is actually the quasi-legislative function of our administrative agencies. So when you say agency, okay, the term agency, this would include the following. Section 2, paragraph 1, Book 7, Administrative Code of the 1987, refers agency to any of the following. We have any department, bureau, office, commission, authority, or officer of the national government authorized by law or executive order to make rules, issue licenses, grant rights or privileges, and adjudicate cases. Government corporations. So what are those government corporations? We have, for example, GOCCs Manila, we have the GSIS, we have PhilHealth, so they are government corporations with respect to function regulating private rights, privilege, or occupation or business. And then we also have another definition for agency. This is this agency refers to officials in the exercise of disciplinary power as provided for by law. So we have here procedural due process. Procedural due process is the minimum requirement in administrative proceedings. What do we mean by procedural due process? We have actually the 7 cardinal primary rights. Okay, when we talk of administrative proceedings, 7 is sila kabuok. So we have number 1, the right to a hearing, which includes the right to present one's case and submit evidence in support thereof. So can you see when you go to a particular tribunal, government agency, administrative agency, you have the right to a hearing, to present your case. No, when you say you present your case, you have to file a complaint before that office, and at the same time, you have to attach your evidence in support of your complaint. Otherwise, that case will or complaint will not be entertained by that office. So the tribunal, when you say tribunal, we are not actually referring to the court, okay? Because when you say court, it's actually the court under the judicial branch of government. Because sa ato ang mga courts, kana sila, judicial na siya, sa judiciary na siya. When you talk of administrative agencies, these are not courts, okay? Even if they are given this judicial function, kung isa judicial function, they are not courts which are under the supervision of our judiciary, okay? Ang atong judiciary at the upper echelon, nasa taas gyud sa ato ang judiciary is the Supreme Court, okay? Supreme Court of the Philippines. Now, tribunal could be that office which would hear the case lodged before them. So the case that would be lodged before them is a case that they have jurisdiction, okay? Dili pwede nga may ilodge nimo ang imong case or imong complaint before the Department of Agriculture, for example, or let's just say COMELEC, okay, COMELEC. And then the case is actually a case against a public official that is not actually elective, no? Elective that does not have any elective positions. Of course, COMELEC doesn't have any jurisdiction over them, okay? So the tribunal must consider the evidence presented to it, so the evidence must be substantial, okay? That's number 4. So the decision that is being decided by the tribunal, the administrative tribunal, must have something to support itself. That's why you need to attach your evidence to the complaint that you filed before that office. Otherwise, the decision would be farce. Walay kwenta ang katong decision. So number 4, the fourth right under the procedural due process when you talk of administrative proceedings is that the evidence must be substantial. What do you mean by substantial? Substantial evidence means such reasonable evidence as a reasonable mind. Kung unsa man tong mga ebidensya nga matong madawat being reasonable people accept as adequate to support the conclusion. For example, na kay i-present ito na i-attach nga evidence sa complaint nga katong evidence kay, let's say, ang evidence kay gibutang dito kay expired gid ang license. So that particular evidence is substantial enough to support the claim that is being that is written in the complaint. Number 5, the fifth right is actually the decision must be based on the evidence presented at the hearing. Now, kani siyang evidence that was presented at the hearing, of course, it is substantial evidence, or it is contained in the record and disclosed to the parties affected, because the parties affected must know what was the basis of the tribunal that decided the case in coming up with a decision. Dili pwede nga ang decision gibasihan lang sa wala sa atong mga tribunal or sa atong officers nga nag-decide sa case. Kay nauban dito mosulti sila nga ang kaso kay whimsical kay sa katanan pagkihimo, ma'am. They just arrived at the decision without any basis thereof, no? So kana siya dili pwede. The tribunal must present the evidence, disclose the evidence, as well as the decision to the parties affected, so that the parties would say, okay, the decision was really justified, okay? So nagi siya basis. The sixth right is that the tribunal or body or any of its judges, okay, matawag yapon yung sa judges, but again, the administrative officer or agency that decides on that administrative complaint cannot be deemed to be under the direct control or supervision of our judicial branch, particularly our Supreme Court. Kay kana sila kay dira gid siya dapit sa atong executive branch. Now, the judge, katong nag-act yun as judge on that particular administrative case, must act on its own independent consideration of the law and facts of the controversy, and not simply accept the views of a subordinate. What do we mean by this? Because there are some subordinates, right? Okay, they are so intelligent, they're so smart that sometimes you are convinced that what they're saying is the truth, or the one that what they're saying is actually the one that you would be basing your decision to or off, okay? So, na mga subordinates ngayon, so you cannot just simply accept the view of their subordinate. Being the administrative officer or the judge to a particular decision, to a particular case filed before your office, administrative office, you must have your independent consideration of the law and facts of the controversy that is filed before your office. You cannot just say nga ako ni siyang gibasihan tungod sa katong gisulti sa akong subordinate nga bright kayo. No, cannot be. Number 7, seventh right. Okay, the border body should, in all controversial questions, render its decision in such a manner that the parties to the proceeding can know the various issues involved. Unsa man gyud tong mga gipang-awayan ani nga complaint, no, inani nga kaso, and the reason for the decision rendered. Of course, you have to see to it that the decision that you promulgate or you promulgated being the judge of that particular case is actually substantial po ang katong imong evidence nga imong gi-support sa imong decision. What were the evidence that you used in achieving or arriving at a particular decision? So this actually kaning 7 kabuok rights, cardinal rights sa due process, procedural due process. Now minimum requirement again, highlight the minimum requirement in administrative proceedings was they were actually laid down in the case of Ang Tibay versus Court of Industrial Relations 69 Philippines 635 in 1940. Okay, so what are the reasons or factors which gave rise to administrative agencies? We have growing complexity of modern life. As society gets more complicated, there are more things to regulate. So unsa man itong mga things that you need to regulate? Of course, because there are so many things that come up now because of our very complicated life. So naagi tayo mga gipang-adra ang mga functions sa atong government institutions. That's why we need to have this more administrative agencies, no? Na ni mga rise of our administrative agencies. Second reason is the multiplication of the subject of governmental regulation. Because again, of the complicated life that we have now, nagiging complex siya, nag-multiply po ang ilang gina-regulate sa atong government. Dili na kaya sa atong particular government to regulate a particular function. Okay? So there is a need for our government, atong whole government, to have these administrative agencies. And the third reason is the increased difficulty of administering the law. We have so many laws nga atong gipang enact sa ato ang legislative branch. Okay? For example, we have this Data Privacy Act. Okay? So the Data Privacy Act, actually, kana siya, uwi mo na siyang ihatag lang dito sa NTC or the National Telecommunications Office or Commission. Maglisod sila. Why? Because ang ilang maginan is dito na sila mag-regulate sila dito sa ato ang mga telecommunications companies. Okay? Now, for example, kana siya is dito siya sa like Jollibee, no? Katong Jollibee gani na-found sila nga guilty dito sa breach, no? Data breach. So Data Privacy Act, kana siya gilay down dira unsa itong mga functions nga dapat gyud mahatagan gyud og attention sa atong government, because there are so many companies here in the Philippines that have been violating this. Okay, ilang ginahatag ang details or information of the citizens to banks or insurance companies or other companies nga bigla na lang dayon magtawag-tawag na lang dayon sa ordinary citizens nga mura bitaw mapugos na lang dayon ang citizen to promote or buy their products or their services, no? For example, na isa ka complainant sulti dito, why is it na akong information, my details were leaked to a particular company, so medyo na-harass na sila. So that's why the government decided via the statute on the Data Privacy Act, it decided to create another office, the National Privacy Commission. So ang katong National Privacy Commission, mao na siya ang monitor, regulate dito, gatanaw dito if these companies here in the Philippines have been violating the law or there's data breach. Okay? And then we have here constitutional status of administrative agencies. So the administrative agency does not strictly belong to one branch. Why? Because administrative functions can also be found or being practiced or observed in other offices found in the legislative branch, in our judiciary. Okay? So nana sila kay manaman po din sila mga administrative functions, but the administrative agency, katong agency, does not constitute the fourth branch of government because we only have 3 branches. What are the 3 branches of government? We have the executive branch, legislative branch, and judiciary. So only 3 lang yun atong branches of government, because these are actually the branches that are actually found in our constitution. So there's separation of powers of these 3 branches lang yun. Now, the role of administrative agencies. Why do we have these administrative agencies? Because of this residual power. Saan yung residual power? When you say residual, salin, okay? The powers given to the 3 branches spill over because of the 3 shortfalls. Sa itong mga shortfalls na ito, no? So, public skying life, multiply subject of governmental regulation, increased difficulty of administering law. So, there's a need for a body. So, kanang need for a body mo na siyang administrative agencies na to, which would act as a catching mechanism. Again, catching mechanism. Otherwise, the 3 branches would collapse. Maglisod sila because the 3 branches, usama itong ginahimo sa itong executive branch, they execute the law, okay? They execute the law for public purpose na siya, public interest involved na siya, legislative, they enact the laws, and the judiciary, they hear and decide the cases lodged before them. So, usaw na lang yung administrative na function. So, there's a need for this administrative agency. Catching mechanism, sila na lang dito. Sila na yung magamit ani. The administrative agency supports the trichotomy of powers. Okay, syempre, kung wala ni sila, magkagidlay-gidlay ni atong mga three branches of government, dili sila maka-function as legislative, as executive, or as judiciary. Now, we have here the creation of administrative agencies. There are two ways actually ni siya, no? Two ways. Kasagarag yun. We have created by Congress, by statute. So this can only, those agencies, administrative agencies that are created by Congress, they can only be modified by Congress yun. Okay? It can, those agencies can only be altered by Congress, can be abolished by Congress if such administrative agency was created by Congress. If the administrative agency is created by the Constitution, it means to say that that agency is performing more sensitive functions. Okay, so what are those three constitutional bodies that were created, of course, by the Constitution? We have COMELEC, COA, and CSE. Katurang tulo, dili labot si CSR, dili labot si NPC, of course, kay mga statute man na sila. Then we have underscoring the independence of the agency, thus it insulates them from political pressure. So we cannot pressure COA, we cannot pressure COMELEC, we cannot pressure CSE because they are constitutional body, they have fiscal autonomy, as in sila own yun nga life, kumbaga. How do these agencies, administrative agencies, come into being? By statute, okay? Congress na siya, legislative act, by the Constitution, of course, napatulog no? And then we have executive orders. Ma'am, you said that by Congress na siya, by enactment, legislative act, and then we have Constitution. Nga nung niabot naman po sa executive order because the law provides for it. Okay, the president, by virtue of his being a president, can also execute or issue executive orders, and these executive orders can also create administrative agencies. But these administrative agencies are only fact-finding agencies lang. Okay, mga fact-finding na sila. Makakita lang sila kung dapat nga makapaayo, makapahinlo, aning function sa executive branch. Now, did you know that the chief executive is not the same as chief of staff, class ha? Chief executive exercises control over agencies and offices which perform rulemaking or adjudicatory functions. Of course, those agencies that are under its supervision and control. Katulad ginasa po sa Office of the President, of course, pwede na gina siya control, as well as those agencies nga sa executive branch, but as long as they perform rulemaking adjudicatory functions. If the agency is created by Congress, of course, you have to consider the law that created such agency. If the law is silent, again, if the law is silent as to the control which the President may exercise, then the President can only supervise, okay? Maka-supervise ra gyud si President, dili siya pwede mag-control ana nga mga ahensya. Okay? Again, if the law is silent as to the control which the President may exercise, the President can only supervise and see to it that the laws are faithfully executed. Administrative agencies are necessary. They are very important due to the inadequacies of executive, legislative, judicial trichotomy. I already mentioned this earlier. Now we go to the doctrine, separation of powers, no? So the reason for the doctrine is kani siya highlighted to prevent absolutism. Dili pwede nga para ra gyud ni siya dinhi sa executive branch. This is only for the legislative branch. This is only for the judiciary. Okay? So ang nay mga offices po, there's this doctrine of a separation of powers because the Supreme Court, for example, cannot assume the administrative function of supervisory control over executive officials. Okay? Because even if the executive official is holding public function and, being public officials, if they are erring public officials, so therefore, they're violated the law, therefore, since that particular violation has something to do with controversial something, so the Supreme Court na lugar ang mag-take over or must assume administrative function, dili pwede. Okay? In Noblejas versus Tihanki, the Supreme Court struck down Noblejas' claim that the Commissioner of Land Registration being entitled to the same compensation, emoluments, and privileges as an RTC ni siyang equivalent sa CFI karon. RTC judge can only be investigated and suspended in the same manner and not by the Secretary of Justice. Why? Because the judges are only under the direct supervision and control of the Supreme Court. Dili na sila under the Secretary of Justice, no matter no matter how hard we try to, internalize that, the Secretary of Justice is justice, the administrative function, the violation of the judge has something to do with his administrative function. Therefore, it must be the Secretary of Justice that must have jurisdiction over his case. No. As long as it is the judge, no, in question, only the Supreme Court lang yun ang may direct control and supervision over such judge. So if you have some complaints against the judge, dito ka mag-file a complaint sa Supreme Court. Okay? Members of the Supreme Court cannot sit as a board or as board of their arbitrators. Of course, because kaning board of arbitrators, they are only executing man sila, executionary man yung ginahimo, no? So dili pwede ang Supreme Court because again, non-encroachment of powers na siya. So there must be separation of powers between the executive branch, legislative branch, and the judiciary. That the judge cannot become a member also of the Provincial Committee on Justice because the Provincial Committee on Justice is not under the judiciary. So of course, na po ni siya encroachment na po if the judge would become a member of such committee. Control of administrative actions. So we have here control. When you say control, it has something to do with the power to change, modify, alter decisions of the subordinates. And then supervision is the power to oversee. So kana sa control, for example, if a subordinate di man necessary nga ubos kay sa katanan subordinate. Let's just say the decision was promulgated or it was issued by the regional director of a particular office. So kanang director actually is under na siya sa secretary, for example. So if you are aggrieved of the adverse decision of the regional director, you can still appeal your case to the secretary of that particular agency. Pwede na mo isaka dito because the secretary has control over the regional director. Okay? So the secretary has the power to change, modify, alter the decision of his or her subordinates. Legislative control. So what are the exercises? No, control of by Congress sa atong administrative bodies. So we have here abolition, appropriation, investigatory, prescription of legislative standards, and prescription of minimum procedural requirements. So when you say prescription of minimum procedural requirements, this would refer to prescribing procedural requirements in admin proceedings. So sama to siya, for example, if the admin proceedings I have mentioned earlier, diba, there are 7 rights, no? For the procedural due process, when we talk of administrative proceedings, and then the legislature, for example, Congress, for example, would prescribe na sila hatag nga mo na lang niya, mga minimum na lang yun, dili na katong 7. So that would be ineffective because there must be a shift to administrative standards. So what can be done here if the Congress, for example, would insist nga ilagyo ning i-change katong minimum procedural requirements in administrative proceedings instead of 7, ilapag yung minimum pag they would make it 4 na lang. So there must be a modification. They should modify the doctrine because when you say doctrine, mama na siyang gilay down no sa jurisprudential man na siya. Tibay versus CIR. So i-change to nila. They have to modify. There must be another case filed before or appealed before the Supreme Court. The Supreme Court has to decide a case again. Tapos ang case nga gi-decide sa Supreme Court mo gawas dito nga 4 na lang. 4 na lang to siyang requirements instead of 7, whatever. So procedural due process gyapon ninyong tanawon. So that's one. Exercise of control of the legislature din the other one is abolition. When you talk of abolition, this is the act of ending. Imong iundang na gyud the existence of administrative agencies. Now, when you say abolition man good, diba, we have mentioned earlier, a law being enacted by Congress that creates a particular administrative office. So the Congress will have the control over that particular agency and it can abolish, it can modify, it can alter the office. Abolition is one. Okay, now this is not effective because we all know that because of multiplication of governmental function, because of the complexity of the roles, the functions in our government, there's a need for these administrative agencies. So it is actually a futile exercise if you're gonna abolish lang ng basta-basta the administrative agencies. If there are some, for example, if you're a congressman, for example, and you found this particular office, administrative office, that's being let's say that office is no longer effective, instead of abolishing that office, ang ginahimo dapat na is ilasang i-investigate what's going on in that office. So for example, kaning PAGCOR, butang na to PAGCOR, wala man inada ang PAGCOR. Let's just say wala na inada ang PAGCOR, or let's just say wala na nag-function ning ubang mga offices kanang PCGG, wala magyapon. So instead of abolishing such office, they have to make some investigation pa, tapos they have to check kung na-follow ba gyud nila ang rules, because kung wala nila na-follow rules, ang usa man imong himon, dili man nimo dapat patyon, no? Baga kung tao pa yan, di man nimo patyon. Di mo na siya i-rehab, di ba? So when you say rehab, siguro na sila ipang check lang diri, change this, change that, add some kuan, kanina the past policy, instead of abolishing such office. Second exercise of control by Congress is appropriation. When you say appropriation, this refers to provision of funds. Now, kada office man they cannot function without funds. Of course, kay magbayad ba ka sa imong mga tao, you need to pay for your employees, you have to pay for the kanang communication expense, kanang overhead costs sa imong office, sa imong mga kuan. So a lot of things must be paid, no, when you talk of government. So appropriation is necessary. So this is very ineffective if i-control lang ni sa Congress. Masuting Congress, dili ko maghatag appropriate of funds, so mag-funds, mag-appropriate of fund, ani nga particular office because this office is not functioning anymore. So that is very ineffective because appropriations are always given whether we like it or not, okay? Before the end of the year, all offices would make some planning, okay? They make some planning, work and financial plan, and then they would do some budgeting and the budget, mga plan nila, financial plan nila, na they would forward this to their head office. Now, katong sa head office, they would collate all the budget from the lower mga offices, okay? Now, after once they collected all of the budget, okay, from the offices, they will now forward this to the Congress, and then Congress mag-deliberate na sila para sa next year nga GAA. So guys, General Appropriations Act. Through law na siya kana mga GAA. So there are always appropriations for the government offices. They're always given. If no appropriations are given, the general public would suffer. Definitely suffer because di naka-function, dili naka-move ang ato ang mga opisina. Third exercise of control by Congress is investigatory. What do we mean by this? This would actually refer to investigatory hearings to uncover abuses of power and corruption. So you can see Senate hearings, for example, nga ilang ginatanaw di pangita nila dito, was there an abuse of power sa inaning nga case, etc., etc. Have you heard of the Anti-Hazing Act, diba? Before there was this 1995, 1994 Anti-Hazing Act, and then later on, because there were other hazing mga incidents na po niya na namatay, so Senate hearing na po sila. So during the Senate hearing, it was found out na, hey, there's a need to amend this law because those owners of places where the hazing rights were conducted, they were not liable. They were not held liable under the previous Anti-Hazing Act. So, katong 2018, our Congress found out that there's a need to amend the law. So, nag-Anti-Hazing Act of 2018 na rin sila. So, investigatory function or control by Congress is effective only as an aid in legislation. Again, in aid of legislation lang siya, and cannot serve the need for constant regulation. Kaya di man na sila mga police. Dili sila korte, okay? Number 4, fourth exercise of control by Congress is prescription of legislative standards, and this would refer to prescribing manner or ways in doing things in administrative functions via legislation. Okay, via legislation. So pag musulti kag via legislation, okay, unsa man atong ginapasabot ana? Pag musulti na via legislation, of course this would be legislative act. You have to prescribe the manner or ways, no? Things in administrative functions. So this is deemed ineffective because the standards should be flexible. The legislature cannot say that this particular standards, wala na ni, dapat ato ni himuon atong standards ngay nani kay dili na siya payo. No, they cannot say that because they are not there in the executive branch, in that office, who can actually determine that such standard is lacking or ineffective. Kaya di naman sila mag-execute. Those people who can actually say what are the standards or what standards should be imposed or implemented, katong nasa opisina. That's why there's a need to be flexible. Okay, to make the standards flexible, efficient. These legislative or people, the Congress, for example, they lack that expertise. The standards must be effective and sufficient. Most of the time, the Congress is not definite because, again, varying conditions, differences in the need for regulation. So those are actually the exercise of control by Congress. Okay. Now, when you say substantial evidence in administrative proceedings, this is the quantum of proof that is necessary for a finding of guilt. Okay. finding of guilt, when it comes to finding of guilt in administrative proceedings, the quantum of proof that you require is actually substantial evidence. When you say substantial evidence, this is the relevant evidence as a reasonable mind may accept as adequate to support a conclusion. Again, for example, if you file a complaint and then you didn't attach any evidence, so what is the evidence that would support your claim? Diba? So there is a need to attach the substantial evidence, and the substantial evidence is that evidence that a reasonable mind may accept as adequate, okay na, to support a conclusion. Let's go now to executive control. Now, executive control, of course, executive, that would be the executive branch, no? By the president. The basis for this is being vested in the president in Article 7, Section 1 of the 1987 Constitution. The general rule is that the president shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws shall be faithfully executed. And this is under Article 7, Section 17 of the 1987 Constitution. However, in the case of agencies being created by Congress, example, NLRC, BIR, LTFRB, that person who is actually trying to attack this particular office or even the president, he must check the enabling law, the law that is created or that was created by Congress regarding the Congress intention as regards the control that should be exercised by our president. If the law is silent as to the exercise of control by the president, then the president can only supervise that particular office. Okay? But in cases where agencies are under the executive branch, the president, of course, general niya, has control. Let's proceed to judicial control. Una na po kay judicial control, ma'am. When you say judicial control by the judiciary, no? Judicial review of administrative actions na yun. Okay, they can review administrative actions, pero layo na kayo na siya. You have to exhaust all remedies, legal remedies, before you can actually file the case before the judiciary. There is no exercise of control if the judge cannot become a member. For example, the judge cannot become a member of the Provincial Committee on Justice because this Provincial Committee on Justice is under the executive branch, not under the judiciary. Or even most of the Committee on Justice, if kanan sa Provincial Committee, it's under the legislative branch po na siya sa iyang LGU, no? So kanin siya on justice, this cannot be under the judiciary, therefore the judge cannot become a member of such committee. Okay. For the Ombudsman, the exercise of control by the Ombudsman, so the Ombudsman can investigate, can prosecute all elective and appointive officials, including cabinet members. Because some of the cabinet members, Secretary of Justice, Secretary of, those are the cabinet members. GOCCs and LGUs within his jurisdiction. Why? Because there are some local government officials, no doubt, that are not under his jurisdiction. Okay, na siya jurisdiction, lahi na siya jurisdiction, you have to go to the Santigan Bayan. No exercise of control sa Ombudsman for those people who can only be removed via impeachment. So the President, Vice President, Supreme Court Justice, Ombudsman, they cannot be removed by the Ombudsman. Okay? The Ombudsman has no control over the case. He cannot also veto, change narito, revise, tanggal, exercise of judgment or discretion by the agency or officer upon whom that judgment or discretion is lawfully vested, because the Ombudsman has no knowledge na siya sa mga technical matters coming under special technical knowledge and training of the agency. So the Ombudsman has no jurisdiction also to initiate investigation into the alleged delay. So for example, if the judge, if you're the complainant, for example, and you file the case against a judge, or let's just say you file the case before the sala of a particular judge, and then there was delay, okay, in the decision and deciding the case, for example, and then because of that, you thought of filing the case against the judge for the delay before the office of the Ombudsman. That cannot be so because the judge, okay, the judge is under the administrative supervision and control of the Supreme Court. The Supreme Court has administrative supervision or control over all courts and the personnel thereof. This was decided in the case of Dublalas versus Office of the Ombudsman. Let's proceed to Part 3, Powers and Functions of Administrative Agencies. Quasi-legislative functions, I have already mentioned this to you during our prelim. So we have here the non-delegation doctrine. Theoretically, the non-delegation doctrine puts a check on the legislature from abdicating paglayo-layo. its duty by delegating its power to make law. Okay, this is corollary to the doctrine of the separation of powers. The later attitude of the Supreme Court is more liberal and is in favor of sustaining the validity of the delegation. Ingon niya sa Supreme Court, okay lang, i-sustain mo ang delegation. But there are matters that Congress cannot delegate, and these are as follows. This actually came out, or this would actually come out in our midterm exams. So what are those matters that Congress cannot delegate? 1 is the creation of municipalities. 2, imposition of criminal penalties. 3, designation of a particular act as a crime. 4, creation of standards on the part of the agency. These matters can only be under the power of Congress. Wala nailay. Then we have here direct requisites for valid delegation. When can we say that there was a valid delegation of the legislative act or power? First is we have the completeness test. When you say completeness test, this is the test wherein it says that the law must be complete in itself. It must set forth a policy to be executed. So complete na ang balaod, you just have to execute the law. The second requirement is sufficient standards test. In this test, you must fix a standard daw kuno. The law must fix a standard, the limits of which are sufficiently determinate or determinable. Makita na nimo sa mismong balaod to which the delegate must conform in the performance of his functions. Again, that delegate, kaya mong gihatagan, ana siya nga power, quasi-legislative, for example. Kaya maghatag na lang siya mga fill in the blanks na lang sa iyang paghimo sa rules. Katong yang gihatag sa iyang balaod, ngayahang basis, must fix a standard. Okay? If the completeness test, the sufficient standards test, if they fail, for a particular case, you would like to know if there was valid delegation of the quasi-legislative act, no, or power to a particular agency, administrative agency. If these two tests are not present, okay, or nag-fail kaning mga two tests, then there is no valid delegation, or the delegation of such legislative act is not valid, void. Now we have here standard may be expressed or implied. Again, ano siya sa case dire nga the challenge law, for example, sa Armed Organic Act, dili man necessary gyud nga kato standard makita lang sa isa ka balaod, because there may be other laws wherein the standards are set there. So, tanaw po di mo ubang balaod po mga related laws before you can say that the law did not set any standard at all. So, what are the cases where sufficient standards test was used? So, we have here those cases with questioned laws or rules deemed to have passed the sufficient standards test, mo ni sila. Cases with questioned laws or rules deemed to have failed the sufficient standard test, mo ni sila katong kay Santiago, Panama Refining, ana. For example, kay Santiago versus Comelec, gawa sa kaso sa atong midterms class. RA 6735, more on initiative and plebiscite ni siya class, is incomplete, inadequate, or wanting, lacking in essential terms and conditions insofar as initiative on amendments to the Constitution is concerned. The Comelec resolution in question is void because there are no standards at all, no legislative policy. Mao na ang gisulti sa case ni Santiago versus Comelec. So the sufficient standards test was used here and it failed. So, void ang Comelec resolution. In the case of Panama Refining versus Ryan, this is a US case. For subordinate rules to be valid, katong mga rules nga mga gipanghatag dito, gipasa sa administrative agency, para mawaging valid, such must be within prescribed limits of the statute. So, na ditong statute, the statute prescribes the limits. Taman ra ka diri ha, dili ka pwede mo go beyond that, creating or granting such authority. The court found out, the US Court, Supreme Court, it found out that Congress had violated the non-delegation doctrine by vesting in the President the legislative powers without clear guidelines, because the President in this case was able to, just have these standards, okay? Butang niya dito. Without clear guidelines, giving the President enormous, as in broad kayo, unchecked powers. So there is encroachment of powers na. The omission of congressional guidance on state petroleum, okay? State petroleum and sa Panama Refining. Production ceilings occasioned the adverse ruling because it allowed the executive to assume the role of the legislature. Nagmugna nagbalaod standards more than the limits, no? Among the guidelines, more than the limits required. Okay, so there was violation of the sufficient standards test. Then in ALA sector shelter, how do you pronounce this? Poultry Corporation versus United States. This was a decision by the Supreme Court of the US that invalidated regulations of the poultry industry. Manok po ni, according to the non-delegation doctrine. And it was found out to be invalid. Invalid use of Congress power under the Commerce Clause because kani siya nanapoy broad ra kay sa katanan. Okay? The limits were not followed. Okay? So given na po ni siya kaning sa main component sa CK President Roosevelt ni siya, no? President Roosevelt sayang National Industrial Recovery Act of 1933, according to them, this is unconstitutional because there was no valid delegation of such legislative act to the president. So I have here permissible delegation. What are those delegations that are allowed? Okay, permissible. Okay, the legislature must establish the standard, of course, via a legislative enactment or law, and the administrative agencies shall only make subordinate rules. Ibasin nila dito sa pinakabalaod. So what are those? Permissible delegation, ascertainment of fact, filling in of details. Okay, lalang gamay-gamay lang para lang mas mo hayag pa ang katong rules. Then we have here administrative ruling or quasi-legislative power. So administrative rulemaking or subordinate legislation is valid as long as it is germane, relevant, consistent, and it only implement the law. Provisions in Book 4, siya. So you can read this in our module. Okay? Let's just go to the important ones. So we have fixing of rates, case on rate fixing, and then licensing functions. So judicial functions. So, okay, we have here questions about the power to issue subpoena. It's pronounced as subpoena, not subpoena. Power to issue subpoena and declaring contempt. Now, subpoena, do all agencies with quasi-judicial functions have the power to issue subpoena? The answer is yes, as long as it is in the exercise of quasi-judicial power. Okay, if that administrative agency was given such power, and even if it is silent, it's okay lang, di po daw, as long as it is vested in the administrative agencies. Test for valid enforcement of subpoena are the following. It must be within the authority of the agency. There must be a law expressly authorizing such agency to enforce that subpoena. Okay? If the demand is not too indefinite. So, for example, there's subpoena ducis tecum. So, when you say subpoena ducis tecum, this is actually an order, actually ordering you to bring before the tribunal the documents, okay, important documents. Then we have here information is reasonably relevant. Okay, they are very important. So the enforcement of subpoena is valid, okay, for the administrative agencies. Now, what is the reason for this? The reason, rationale, is the power to adjudicate will be rendered inutile if it cannot issue or execute the subpoena. Now, we have here warrants of arrest and administrative searches. Administrative searches, okay? Now, can administrative agencies issue warrants of arrest? No, okay? No. In Salazar versus xoxo, it was held that under the 1987 Constitution, only a judge may issue search or arrest warrants. The exception to this general rule, wherein only the judge can only issue search or arrest warrants, is in cases of deportation of illegal, undesirable aliens following a final order of deportation. Again, there must be a final order of deportation muna before you can issue search or arrest warrant to undesirable aliens, illegal aliens in deportation cases. This is for the purpose of deportation lang. Now, in Qua Che Gan versus Deportation Board, two ways of deportation, of deporting, are through the Commissioner of Immigration and the President after due investigation. Okay? So, mao na siya ang gihimo nila sa case ni, where was that? Qua Chi Gan versus Deportation Board. Question: do agencies have the power to impose fines and penalties? The answer is yes. In the case of Oceanic Steam Navigation versus Trinaham, the Supreme Court said, or it laid down the tests. What are the tests for the validity of imposition of fines? First, you have the subject matter. The subject matter is within the control of Congress. So, naagi na siya, Congress na siya ang makakuha na to. Subject matter for the imposition of fines and penalties. Second is that the penalty is administrative or civil and not criminal, which would involve deprivation of property. Because when you say that the criminal fine or penalties na siya, courts ang maka-impose na. Okay? Not the administrative agency. Power must be expressly conferred to the administrative agency. So, unsa man nato makita aning tanan? That power must be expressly authorized. Gihatag na ng authority ang administrative agency for that power. Otherwise, dili sila pwede ana maka-implementar ang klaseng of function or power to impose fines and penalties. Okay? You cannot say na, it's implied man. No, you cannot say that. Okay. Do all agencies with quasi-judicial functions have the power to cite for contempt? No. Power must be expressly granted in the agency's charter. Again, expressly granted. Dili siya pwede implied. If there's no law, then you must invoke the aid of the RTC. You go to court. Para makita nimo kung pwede ba siya ma-cite for contempt. Okay, so what is the reason for this? Power to punish for contempt inherently is judicial. So this is inherently judicial ang power to cite another person for in contempt. Can immigration authorities issue warrants of arrest against undesirable aliens? Okay, ato na siya balikon because this is actually part of your exam. Yes, but only if issuance is pursuant. Again, there must be a final order of deportation. Immigration authorities cannot issue warrants for purposes of investigation, as the Constitution provides that only judges can issue warrants to determine probable cause. Probable cause, ano siyang cause if this person there's this cause to hold this person for trial, anak siya, or nabagin siya sa hakyot. Note that the Constitution does not distinguish between warrants in a criminal case and administrative warrants in administrative proceedings. Okay? Now, we proceed to judicial determination of sufficiency standards. You can actually read this on your own. These are very understandable. Okay? Self-explanatory. So these are the following cases wherein the sufficient standard tests, where the sufficiency of standard test was used. So we have here the following. They have passed the sufficiency of standards test. Number 1, interest of law and order, public interest, justice, equity, what is moral, educational, or amusing, adequate and efficient instruction, sound and reasonable discretion, and promotion of simplicity, economy, maintenance of monetary stability. These are the cases, Ruby versus Provincial Board. These are the cases wherein the sufficiency of standards test were used, and yes, they passed the sufficiency standard test. Finally, we have here part 4, chapter 4, administrative procedure. What are the 7 cardinal primary rights as held in Antibay versus CIR? So we have here the right to hearing, right to have evidence considered. Decision must be supported by evidence, substantial evidence, transparency of records, independent consideration of the judge, and the decision must reveal relevant issues. Now, if one of these rights, 7 man sila class, one of these rights absence of one of these rights, this is now sufficient to question the administrative proceeding. But then again, you have to consider that the presence of a party at trial is not always the essence of due process. Again, you don't need for all of the parties to the particular complaint be present during trial, because that is not always the essence of due process. What the law only requires is that parties to a particular admin case be given notice of the trial and an opportunity to be heard. When you say opportunity to be heard, not necessarily you go to the tribunal and then you just say your piece, okay? Or you make your defense. No, that is not it. When you say opportunity to be heard, you can actually file a counter affidavit, and of course you attach your corroborating evidence, affidavits of your witnesses. The right of a party to confront and cross-examine opposing witness is fundamental right, which is actually part of due process. Now, for example, ma'am, you said that it's okay not to be present during trial as long as you were given the chance to be heard via counter affidavit or with the attachments, evidence. What about this one? Right to a party to confront. I was not able to confront and cross-examine the opposing witness. So you said that this now is is actually part of due process. Now, was there a violation? Again, if the respondent was able to, he was given that opportunity and he did submit his counter affidavit, attach all the affidavits of his witnesses, etc., all the substantial evidence. As long as he was given that opportunity, and of course, you can debunk the reply, whatever, of the complainant. As long as you were given that right, that's already fundamental right. Okay, fundamental right to confront. You don't need to face as in personal, face-to-face, talk face-to-face with or make a face-to-face confrontation with the complainant. Now, if without his fault his right to cross-examine is violated, he is entitled to have direct examination stricken out. For example, he was not able to adduce other evidence, or additional evidence, and there was a hearing, and during the hearing, there was this direct examination of the witnesses of the opposing party. Now, since he was not given that time to adduce additional evidence to support his claim or to debunk the allegation of the opposing witnesses, so there was already violation of his right to confront or cross-examine the opposing witnesses. If this happens, then the respondent is entitled to have the direct examination of that opposing witness be stricken out. Dili na siya apilon dito sa rulyo. Dili na siya apilon dito sa pag-decide basehan sa pag-decide sa tribunal. The law in prescribing a process of appeal to a higher level contemplates that the reviewing officer is a person different from the one who issued the appeal decision. For example, labor ni siya case. You are the aggrieved party. You are the complainant. Okay, private employee. You are laid off. So you filed an illegal dismissal case against your employer before the labor arbiter, RAB. And then the labor arbiter issued a decision, order, that there was no illegal dismissal. PAC, no illegal dismissal. Now, you were not satisfied with the decision, of course, of the labor arbiter. Now you appealed your case before the NLRC Commissioner, National Labor Relations Commission. So taas na, i-appeal nimo. Daw kay the labor arbiter is now the commissioner. And the case was also filed before his office. Ito na rafo saya. So he penned again another decision. And of course, the decision was same, ibidim, that there was no illegal dismissal. What happens then? So that particular decision is already a farce, meaningless, because the reviewing officer is the same person who issued the appeal decision. This cannot be done. If this happens, there's already a violation. There's a violation, you can question the administrative proceeding. Okay. Evidence and record must be fully disclosed to the parties. All evidence must be disclosed to the parties. No matter how trivial the evidence may be, all evidence that were attached to the complaint, to the counter affidavit, everything must be disclosed to all the parties, because the parties can then check if the decision of the officer, reviewing officer, administrative officer, who decided the case was justifiable, or was there justice or not. In Matthews versus Eldridge, the U.S. Supreme Court enumerated the 3 factors. This actually is part of your exam. So the 3 factors determining constitutional sufficiency of admin procedures, we have 3 private interests that will be affected, risk of erroneous deprivation of such interest, and probable value of safeguards. And then finally, we have public interest vis-a-vis government costs. Always remember these 3 factors determining constitutional sufficiency of admin procedures, because this would come out in your midterm exams in activity 2. Okay, so you must do it in sentence format. So we have here administrative procedure, notice and hearing, when it is required and when it is not required. It is required, notice and hearing, when law specifically requires notice and hearing, and when it affects a person's status and liberty. Of course, so that you can have your day in that tribunal, you can tell the court that, hey, you can just deprive my liberty. Okay, so this is very important. Notice and hearing, if it affects your status, okay, as well as your liberty. But in the case of mere conference, chika-chika lang, no? Nga sa inana siya. You can only have the notice and then submit your counter, your evidence. Okay? If administrative action is based on undisputed fact, wala na ilalis sa mga facts involved in that particular case, not a quasi-judicial function, okay? Notice and hearing may be dispensed with. You don't need to have this notice and hearing. Hindi na kailangan mag-hearing. Urgent reasons, no more hearing involved or necessary. So, ayan siya. So what are those instances when notice and hearing are not required? So in promulgation of judgment, decision should state the facts, issues, law. On a general rule, the decision should state the facts, issues, and law. So this is required if this is actually the normal, no, the standard. However, there are times when there is substantial compliance, so there's no more violation of the due process clause. And it is not necessary to have all these facts, issues, law in the particular decision. If there was already a finding attached to the decision by the examiner. So if you're going to have all these facts again reiterated in the decision, duplicitous na siya and redundant na. So there's no need in that particular instance to have all of these facts, issues, law being stated in the decision. Okay. Now we proceed to pendency of criminal case will not divest the deportation board of its jurisdiction over undesirable aliens in a deportation proceeding. Okay. And also for CHR, okay, it cannot issue cease and desist order since the CHR can only investigate. So the CHR is not judicial tribunal, ha? So the power to issue cease and desist order is reserved for quasi-judicial and judicial powers. The CHR cannot do that. It can only investigate violations of civil political rights, and it cannot hear, decide cases just like ordinary courts. Okay, so I think that would be all for our module. Let's proceed to our midterm exams. So I have the password. All right. Password. Okay, so this is how your midterm exams look like. So there are some typos here. In your Google form, there are no typos. I was only able to save the one which the draft actually. So I don't need to discuss number 1 because you have already answered this during your prelim exams. Let's proceed to number 2. Colleen was asked during examination about admin law. She was asked which of the following is or are the correct definition of admin law. Letter A, admin law is that branch of consti law that deal with rules relating to powers and procedures of government agencies, which is legislative power. Is this the proper or the correct answer? Or letter B, administrative law is that branch of public law dealing with the doctrines and principles governing the powers and procedures of admin agencies, including, especially, judicial review of admin action. Letter C, A and B are correct. Letter D, none of the above is correct. Number 3. Which of the following is the correct definition of procedural due process? It refers to a right to a person to a hearing in a court of law. Is that the correct answer? Are you sure? Letter B, it refers to that most important requirement of admin proceedings wherein the court has to consider the witnesses presented by each party to a case. Is that the correct answer? Letter C, it is the minimum requirement in admin proceedings wherein the evidence presented must be substantial. Or is it D, A and C are correct? Number 4, the term agency would include the following. A, include, okay, include. Which of the following would be the definition of agency? A, government corporations with respect to function regulating private right, privilege, or occupation or business. Officials in the exercise of disciplinary powers as provided by law. C, any department, bureau, office, commission, officer of the national government given the authority to make rules, issue licenses, grant rights or privileges. Letter D, A and B. Letter E, all of the above. Letter F, none of the above, or you can actually write your own answer. Okay, number 5. In administrative proceedings, the board or body should A, consider all the pieces of evidence presented by the parties. Evidence to be presented must be able to pass the test on proof beyond reasonable doubt. Beyond reasonable doubt. Is this the kind of proof that we need in administrative proceedings? Proof beyond reasonable doubt. Letter B. Likewise, consider the criminal aspect of the case if necessary and render a decision on the same. We're talking of administrative proceedings. Letter C. Render its decision in such a manner that the parties to the proceeding can know the various issues involved. They should know the various issues involved and the reason for the decision rendered by the tribunal. Letter D. Collate and gather evidence based on their independent investigation or research to strengthen the promulgation of its decision. Which of these choices is the correct answer to number 5? Number 6. In the case of Ang Tibay versus Court of Industrial Relations. So, the case of Ang Tibay versus CIR is A. The landmark case related to the study of admin law, wherein the decision of the court was focused on determining the relationship that existed between the employees and employers. Is that the correct answer? Letter B. The landmark case related to the study of admin law that laid down the maximum requirement in admin proceedings. Letter C. The landmark case that discusses the kind of procedure to take by any government agency in deciding cases where public personalities are involved. Or letter D. The landmark case that discusses the minimum requirement in admin proceedings. Choose A if you think it's correct, B, or C, or D. Number 7, in the case of Ang Tibay, the court ruled that A. The judge must act individually, considering the facts of the controversy, but if necessary, accept also the views of a subordinate, wrong spelling. So, in this case, should the judge or the person who would decide on the case, admin case, also accept the view of the subordinate? This is what A is telling you. So is this the correct answer? Letter B. The tribunal hearing the case must act independently, weighing the law and facts of the case, and not simply accept the views of a subordinate. Is this the correct answer? Letter C. The tribunal hearing the case must weigh both pieces of evidence presented by the complainant and the respondent, as long as the same are of the same probative value. Letter D. The judge or tribunal hearing the case must disclose the evidence presented to both parties involved in the controversy and inform the same that those evidence shall be forwarded to the High Court. We're talking of High Court now, on appeal. Number 8. Which of the following is the best answer? Actually, the answer to this is very, very easy. You can just reading through the choices, you can actually discern or check which is the correct answer. Admin agency actually is deemed DOSHA as the fourth branch of government. Letter B, admin agency is not only apparent in the executive branch but may likewise be found in the legislative branches of government. Letter C, the admin agency does not strictly belong to one branch of the government. Is this the proper answer? Or letter D, the agency constitutes fourth branch of government. Which is the correct answer? Number 9. Which of the following is not a factor which gave rise to the creation of admin agencies? Letter A. Okay, so you can choose which of the following is the correct answer. Just choose, check on the module. Number 10. Which of the following statements is wrong? Which is wrong? Okay, so just check which is wrong based on the definition of admin law. Number 11. Okay, I'm gonna put this here. Okay, so that you have time. Okay, more admin agencies now created. You can screenshot this if you want. Number 11, true or false. In determining whether delegated power is valid or not, the sufficiency test may solely, the sufficiency test may solely, you have actually answered this during our prelim, solely be complied with. Okay, check on the choices, true or false. Number 12 to 14. If you see this 12 to 14, it means that you have these particular items are equivalent to 6 points. Okay, the powers given to the 3 branches of government spill over because of the 3 shortfalls. And which of the following are the 3 shortfalls? So you go back to your module, check which are the 3 shortfalls. Okay, I've already discussed this earlier. Okay, you can do some screenshot for this particular slide or page. Number 15, true or false. The chief of staff, not chief executive, chief of staff exercises control over all the agencies of the government, performing rulemaking power. A, true, since he or she is the one who sits at the top and oversees those under him or her. Letter B, false. No, the Chief of Staff is not the one who exercises control over all agencies, but the heads of the rulemaking agencies. Letter C, false. The Chief of Staff does not exercise control, not perform rulemaking powers. D, true, found in module. Number 16 to 18, admin agencies come into being by. Okay, you chose which is the correct answer for 16 to 18. Number 19, which of the following is not correct? Again, when you answer this one, we're going to use the Google form. Okay, the Google form, so you just tick the correct answer. Which of the following is not correct? Okay, which is not correct? Not correct again. Okay, there's E and F, so be very, very wary. Be very, very wary. You should check which is not correct among the choices. Not correct. Number 20, which of the following sentences is correct? I've already given this to you. Okay? Okay, you do a screenshot to this one. Number 21, which of the following sentences is correct also? I already gave this to you also. Okay, you do a screenshot if you want. Discuss this with your classmates, my dear students. 22 to 24. The three branches of government lack the following, thus the increase of admin agencies. Okay, which of the choices? These are actually equivalent to 6 points. Number 5, 25 I mean. Which of the following is the reason for the doctrine of separation of powers? A, to prevent absolutism. B, every branch is powerful on its own. Letter C, dichotomy of powers. Letter D, local autonomy. Okay, which is the correct answer? Number 26. Abolition of admin agencies is an exercise of control by Congress. Is it effective or ineffective? Why? A, it is effective since it is the Congress that created the admin agency via legislative enactment. The Congress can therefore abolish it anytime if the office is found to be not doing their functions. B, this is ineffective since admin agencies are necessary, especially since they are created for governmental regulation. Letter C, depends. If the agency is found to be inept, then Congress can abolish it any time, considering that the law gave it such control. Letter D, this is a case-to-case basis which depends on the facts and the admin agency that we are talking about. Number 26. Investigatory exercise of government of control over a government agency or admin agency is ineffective or effective. Why? Investigatory exercise, okay, of control by the Congress. It is ineffective since the admin agency has its own investigatory department. Thus, that exercise. Letter B, this is ineffective since Congress is not supposed to investigate but purely makes laws. Letter C, it depends. If there's a need to investigate, then Congress should investigate but has to collaborate with the police. Or letter D, it is effective only in aid of legislation and cannot be done as a constant regulation. What is the correct answer to 26? A, B, C, or D? Number 27 to 30. Taluha is a public official assigned in Surigao del Norte. A complaint was filed against her by an anonymous taxpayer, Anonym. The complainant alleged that Taluha is receiving bribes from local businessmen to expedite the issuance of mining permits without securing and attaching the mandatory requirements. The complainant attached the certified true copy of mining permits without the mandatory requirements, which the complainant secured from the MGB, and photos with the date and stamp of Taluha accepting the alleged bribes from said local businessmen at a popular coffee shop during office hours. Would the attachments be admissible as evidence against Taluha? Why or why not? A, no. The evidence cannot be admissible as evidence because the complaint is filed by an anonymous complainant. Such complaint may just be a way to mar the reputation of Taluha as a public official, nothing more. You know what? In administrative proceedings, or when you file a complaint against a public official or employee, you can do so even if it's an anonymous complaint, okay? Please bear that in mind. Such complaint may just be a way to mar the reputation of Taluha, but in filing anonymous complaints against a public official or employee, you must attach substantial evidence to support your complaint, okay? Letter B, yes, the evidence can be admissible as evidence since the same show in clear detail the violations of Taluha as a public official. Letter C, it depends. There should be a need to determine the genuineness of the so-called evidence. If the evidence are found genuine, then that will be the time that the same can be admissible as evidence. Or letter D, yes, the evidence can be admissible as evidence. The fact that the complaint was filed by an anonymous complainant is of no moment. When you say of no moment, it is not it is not necessary that the complainant show or state his or her name. The tribunal or body hearing the admin case of Talua should consider such evidence as substantial. So which is the correct answer, A, B, C, or D in the case of Talua? 31 to 33 on June 30, 2016. This is actually the Executive Order number 1. You can actually find this everywhere in the official gazette even. President Duterte issued Executive Order number 1, which reorganizes the admin structure of the Office of the President. Such executive issuance. Okay, now we have mentioned earlier that the President can issue executive order to create offices under its jurisdiction. Okay, such executive issuance consolidated the office and functions. So it consolidated the office and functions of the Office of the SAP, the Office of Appointment Secretary, and the PMS or Presidential Management Staff under the SAP. Now all of these 3 offices are now under the SAP, and under Executive Order number 1, it created the Office of the President Events Management Cluster. Mina then was holding a position of director under the PMS, Presidential Management Staff, which is actually an office that was consolidated with the SAP, Office of the Special Assistant to the President. Mina was now demoted to chief. From director, she is now chief at the Events Management Cluster. She now complains and said that the President cannot do such reorg because that function is with the legislature, and there must be an enabling law, a statute that should be passed for such reorg. So you decide. A, Mina is correct. The exercise of control abolition is with the Congress. The President is not given such power to abolish and reorganize Mina's office. Letter B, Mina's contention is wrong. Her office, the Presidential Management Staff, is under the Office of the President, and also the Admin Code of 1987 provides for the continuing authority of the President to reorg the admin structure of the Office of the President. Is that the correct answer? Or letter C, Mina's contention is correct. Although the PMS is under the Office of the President, the Admin Code does not specifically provide such power to demote her. If the law is silent, the President cannot exercise control but merely supervision. Now, if you encounter this particular problem, for example, you have to check the Admin Code of 1987 if the President was given that authority to reorganize the office, okay, or not. Letter D, Mina is wrong. There's a provision of law that states the President, being the head of the country, can reorg the executive branch at any time and as he or she wishes. 34 to 36, Justine filed a criminal case against Director Mandugas of the DILG. The case is still pending before the sala of Judge Dimatulin since 2017. Now, on January 20, 2021, Justine filed before the Deputy Ombudsman an admin complaint against Judge Dimatulin is the person in controversy now, for the unnecessary delay in hearing the case he filed against Director Mandugas. Now, will his case prosper? Decide. Yes, his case will definitely prosper because the Office of the Ombudsman has jurisdiction over this case. Judge Dimatulin is a public official, and as such, he should speedily dispose the case filed before his sala. His inaction is proof that he is not being accountable as a public official, and therefore, an admin case should be filed against him before the Office of the Deputy Ombudsman. Is this the correct answer? Or letter B, no, this case will not prosper. Although the Office of the Ombudsman has jurisdiction, as a judge, it is of public knowledge that case dockets have been filed, before their sala on a daily basis, both for criminal and civil cases, and it is understandable that criminal cases such as the one filed by Justine would take time to be heard and decided by a very busy judge with hectic schedule. Or letter C, yes, this case will definitely prosper. Judge Dimatulin is accountable to the people, all people, and to the public. He should remain at all times dispose cases faithfully and with justice. An inaction of more than 3 years is unjustified. Or letter D, no, this case will definitely not prosper. The Ombudsman, according to letter D, has no jurisdiction to initiate an investigation into the alleged delay in the disposition of judicial case. According to letter D, it is the Supreme Court that has administrative supervision over all courts and the personnel thereof. Number 37 to 40, the following are matters that Congress cannot delegate. Just check the module. What are those matters that Congress cannot delegate? Okay? Choose A, B, C, or D. Let's proceed to 41 to 43. In the case of Santiago versus Comelec, What was the decision of the court as regards COMELEC Resolution number 2300, insofar as it prescribes rules and regulations on the conduct of initiative on amendments to the Constitution? A. The court ruled that COMELEC resolution was valid since it was in accordance with the OEC as well as RA 6335, entitled an act providing for a system of initiative and referendum and appropriating funds therefor. Letter B. The court ruled that the COMELEC resolution was valid since it was in accordance with the provisions of RA number 6735, entitled an act providing for a system of initiative and referendum and appropriating funds therefor. Letter C. The court ruled that COMELEC resolution was void. It held that COMELEC cannot validly promulgate rules and regulations to implement the exercise of the right of the people to directly propose amendments to the Constitution through the system of initiative. It does not have that power under RA number 6735. Or letter D. The court ruled that COMELEC resolution was void. It held that COMELEC cannot validly promulgate rules as the same is misplaced. For the laws and regulations referred to therein are those promulgated by COMELEC under Section 5A of under A Section 5 of Article 10 of the Constitution. So which of these choices is the correct answer to number 41 to 43? 44. The following have been held to have passed the sufficiency of standards test except, okay? Check the word except, okay? Interest of long order, inadequate, inefficient instruction, public interest, and unreasonable discretion. A, B, C, or D. 45. The following consists the 7 cardinal primary rights related to admin proceedings except again. Okay, which is nawawala? Saan dito ang naiba? A, B, C, D, E, or F. And then we have here finally, 46. The right of a party to confront and cross-examine an opposing witness is a fundamental right which is part of due process. Now, Celine wasn't able to cross-examine the opposing witness since there was no hearing in the admin case against her. This is not here, her. However, she received the complaint with the affidavits of the witnesses. Was there a violation of Celine's right to due process? A. Yes, it is clear that her right to due process was violated since she was not able to confront the opposing witness. Letter B. Yes, her right not here, okay? Right to due process was violated since she was not able to examine whether or not the opposing witness's testimony was genuine and was not done out of coercion. Letter C. No, her right to due process was not violated since she received the complaint with affidavits of the witnesses. Okay, she received the complaint with affidavits of witnesses, so there was no violation of her right to due process. She can always file a counter affidavit and debunk or refute the affidavits of the opposing witnesses. D, A, and B are correct. E, B, and C are correct. Or F, none of the above is correct. Choose the correct answer. Activity 2 is an essay, so you need to check your grammar, syntax, spelling, and you need to make it or answer in sentence format. Capital letter for the first word and then end it with a period, okay? Please do not hyphenate. Please do not put any asterisk. Please do not write number 1, number 2, number 3, okay? Please follow instruction. In the U.S. case of Matthews versus Aldridge, this is a U.S. Supreme Court. I have already mentioned this to you earlier. What were the 3 factors determining constitutional sufficiency of admin procedures? So when you answer this one, you say, the 3 factors determining constitutional sufficiency of admin procedures are, okay, period. Now, please, sentence format. I don't want you to capitalize your letter, your words, okay? Only capitalize the first word. Number 2, Celine Sebastian is facing criminal charges and she fled the country. Solis, a private prosecutor, filed a motion praying the court to issue an order directing the NBI and DFA to take appropriate actions for the purpose of having the accused brought back to the Philippines so that she may be dealt with in accordance with law. The court granted the motion. Now, the DFA secretary, by virtue of the court's order, asked the ambassador to the USA to cancel the passport issued to Sebastian and to compel her to return to the Philippines. She has to return to the Philippines, says the DFA secretary, to answer the criminal charges against her. Sebastian now wrote to DFA secretary to reconsider the action taken against her and filed a motion praying that the respondent court reconsider its order. Now, should Sebastian be accorded notice and hearing in this particular case prior to the cancellation of her passport? Yes or no, and then state your reason. Decide. Again, yes or no. So you say yes, period. Sebastian should be accorded notice and hearing prior to the cancellation of a passport because under rah, rah, rah. Okay, that's how you write it. Or you say no, no. Sebastian did not be accorded notice and hearing prior to cancellation of a passport because rah, rah, rah. So you state the law that you are going to apply in her particular case, then end it with a period. Sentence format, first word would be capitalized, and then the rest would be, small letters. And of course, check your grammar, check your sentences, check your spelling, check your syntax, please. Ayaw po blabda, okay? So that would end our midterm exams. I hope that all of you would review your answers before you submit your exam because you are only allowed to answer once. Again, I repeat, my dear students, you are only allowed to answer once. That's on April 29 until 10 p.m. No more retake. You only have 2 hours. 2 hours. So if you took the exam at 6 o'clock in the evening of April 29, you have to finish it by 8 p.m. that day. Okay? I can check the time. There's actually a timestamp to all of your Google Forms. You will be taking the exam via Google Form. You cannot take the exam by printing it and then you answer the printout and then you submit and then you tell me that you don't have any internet connection because the Google Form is actually very small lang siya plus. You only need a few data, okay, to answer the Google Form. It's very, very small lang siya. So it won't need your mobile data. It won't take so much of your mobile data. So dili kay makuha ang inyong mga funds din na for your TikTok and everything. By the way, when you answer Google Forms or online exams, make sure that you have already cleared your cache or cache, whatever, how you pronounce that, okay? Check the history and then clear para dili mo malangan. And then see to it, of course, you have to review. Review your answers, check those missing or those items that you were not able to answer. Okay, na may mga missed na mga questions nga wa ninyo nga answeran. And then, of course, you actually chose the correct answer cue. Okay? You decide with your classmates since I've already shown you your midterm exams mismo jud, except of course the mga misspellings anino. Ako ni siya ipang-check pag kung mao ba ni spellings. You check with your classmates, review the midterm exams with your classmates. I will no longer send this via GC na to class ha kay check na nako ni siya. Hinahinay ko na ni siya. So check with your classmates, discuss with your classmates what could be the proper answer to the questions or MCQs as well as the essay in this particular midterm exams. I will be exempting those students who will get perfect scores for this midterm exams. Please naman, tabangi po ko ninyo para di na nata mag-finals. So, kani siya, if you get the perfect score, okay, if you get the perfect score, no need for you to take the final exams. Meaning to say, uno na mo sa final exams, uno pa mo sa midterms. O diba, masaya ang life. So, what would you do now? Study for this. I don't need you to study every day. Just discuss this with your classmates. Class, please discuss this with your classmates. Send information, okay, mag-information drive mo with your other classmates who were not able to see this or watch this, okay, so that they will also get perfect scores. If I see that most of you were not able to get perfect scores for this, I will be forced to give you a much harder final exam, okay? So, tinabangay ng the class, okay? So, if you have questions, please raise your questions via our Google Classroom or our GC the Messenger, GC group chat nato. And then I will answer them. So, it's okay now for you to view this. Balik-balik ko ninyo nagbasa, balik-balik ko ninyo screenshot, it's okay. You can even save this video sa inyong kuan and then you can discuss this with your friends. The admin office, okay, sa atong mga satellite campuses, kung asa mo na bilong, na sila yung mga free wifi, so you can go to your free wifi there and then start answering with your classmates. Okay ra gyud kay nasa ako kay mag-discuss man mo. I did not give you man pod kung sa gyud ang answer gyud exact answer. So pwede mo mag-discuss. Okay, so if you have questions, again, raise them via GC, and this would formally end our midterm module online discussion. I hope that you were able to learn from this exercise. For those who are not students of mine, pasensya na lang mo if you don't understand Bisaya. Okay, mag-learn na mo Bisaya. Again, this is Attorney Hani. Thank you for watching our online discussion for the midterm coverage of the admin law for my BSU, beloved BSU students in Baungon and Alubihid satellite campuses. Again, for those who haven't subscribed to my YouTube channel, please subscribe. I will be having this online discussion in the succeeding months or weeks. And I hope that you learned something from this video, especially if you are a public servant. Also, hit the notification bell for more videos like this. And maybe in the future, I will have some videos or online discussion on other related or other laws. BUKSU, hazing, balik ko na po ako to hazing, and other laws that are applicable to our daily lives. Thank you very much for watching. I'll see you in my next videos. Goodbye. Assalamualaikum warahmatullahi wabarakatuh.